for example, I had an expert one time, I kid you not, and he was constantly, his reports were spelling errors, grammar errors, spelling errors, grammar errors. And I kept overlooking it, grumbling until the day his report came and he had signed in his signature. He misspelled his own name. I'm not kidding.
Welcome to The Defense Never Rests with Morgan and Akins, your monthly dose of uncommon sense about all things legal and some that are not.
Hi, everyone. Welcome to this episode of The Defense Never Rests. I'm your host, Megan Henry, joined by my co-host, Nate Bolander. Hi, Nate.
Good morning, Megan. How are you?
Good. This is our first podcast of 2022.
Mm-hmm.
Thank you for being my first co-host.
I'm your first co-host this year. I was the first one to be on that, whatever you're calling that series where you ask your colleagues really in-depth questions that made me nervous.
Yes.
A lot of firsts with me.
Yes. And, I'm going to put you on the spot a little bit, Nate, but, and it's mentioned I think we mentioned a few times in this podcast, but you have baby Bolander's on the way any day now, baby girl. So we're highly anticipating her arrival.
No one's anticipating her arrival more than my wife, who has slept in a month. But yeah, we're all our family, friends, and you guys are all really excited, and that's awesome. So
yeah, I don't know if it's been a while. It's been a while since someone in our office a wife or themselves have had a baby. So it's exciting for all of us.
That's what I said when my wife and I were going to start trying. I said, our office needs a new baby. So that was the driving impetus behind it.
You did it for us, not to grow your own family, just for the Morgan and Akins.
My law firm. That's right. Yep.
Well, today I'm excited for our podcast because we have on Morgan Dooley and Porter Nelms, who both have been on the podcast before. And Morgan was on a few months ago to talk about do's and don'ts of defense counsel. And when she was on, I think we got to topic number 2. We barely even scratched the surface. So I thought it'd be a great idea to do a part 2 and have Porter come on as well. So we're going to just dive into, defense counsel do's and don'ts from the view of an adjuster. So I think, adjusters out there will appreciate their insight. And I think attorneys especially will appreciate, what they look at as, things that they like to see or don't like to see. And it's some good pointers for all of us, I think.
And I think above all, they'll appreciate their candidness and transparency, because I think sometimes things are hidden behind emails and you try to fluff things. And as we know, Morgan especially is not do that. She's very to the point.
Which I appreciate very much.
I do too. Yep.
So with that, let's bring them in. Good morning, Porter and Morgan. Thank you for joining Nate and I this morning on the Defense Never Rests. I'm so happy to have both of you again.
Thank you for having us.
And we were talking briefly, or Porter and I were talking briefly in the chat beforehand, but Porter has a snowmageddon, is in the midst of snowmageddon in Middle Tennessee, which I think is making its way to, at least to me, to South Jersey. So, how was your commute to the office today? Uneventful, I hope.
Yes, very. The visibility was low and the cars are going slow. It's going to be an interesting next few days.
Yeah, well, and I mean, Morgan, if I remember correctly, you're in California too, so you don't have any snowmageddon.
No, I'm actually in Northwest Arkansas. I grew up in California, but I've been out in Arkansas for 28 years now.
Okay.
So yeah, we had snow the other day. We may be getting snow today. I don't know, but I've worked remotely for 14 years. Yeah. So yeah, my commute is nothing.
Well, I imagine though, if you get even an inch of snow where you are, it probably causes a lot of havoc.
No, it's the ice.
Yes.
Ice is what, and we don't get as much, I lived in Colorado for a couple of years. That was snow. But we get usually more ice than we do snow, and the ice is a problem.
Yeah. Well, Nate's in Northeastern PA, and they don't even blink at it unless it's over a foot.
Yeah.
I'm in the heart of the Blue Ridge Mountains, and we love getting 6 inches minimum. We just, it's that's a normal day for us.
So does everybody there go, clear out all the milk and bread and butter like they do here? I mean, I swear, if it's a quarter inch of snow, oh my God, we have to have bread, milk, and butter.
Not so much, because everyone has the means to get around. I mean, you pull into the local grocery store, it's all SUVs on huge tires or pickup trucks. So
nice.
I think that, they don't really mind that, but
yeah, no, everybody here, you got to have bread, milk, and butter for whatever reason. I have no idea.
We get that on the threat of the bad weather. They'll
Yeah.
paper towel, toilet paper crisis of
Yeah.
things are, and it's amazing the things that are empty now.
With COVID.
A lot of beer, milk and bread, of course, will be gone. It's interesting to see what people take, and then you throw in this homeschooling or virtual school, and it makes going to the grocery store an interesting venture. I'll say that.
Well, and so now we know where all the toilet paper went in March of 2020. It was
Porter's got it.
Yes.
Yeah, Porter's got all the toilet paper.
It's in a spare bedroom.
Check his basement.
Yep.
Exactly. I won't tell you my eBay surname so that you won't.
Well, we're here today to talk. It's kind of like a part two, because Morgan was on a few months ago to talk about, defense counsel pet peeves. And, Porter, you had reached out to me after you listened to the episode and you're like, man, she is speaking my language. I was like, great. We already talked about doing a part two, because I think we only scratched the very tip of the iceberg of, pet peeves for defense counsel that you may have. So I'm really excited to kind of dive in today with both of you and get each of your perspectives of, things that drive you crazy, or even some things that you might like. And I'm sure a lot of attorneys out there will tune in, gladly listening to get your tips.
Well, in reviewing what you went over with Morgan, and she's posted about it since, brief, concise, and grammatically correct.
Oh, yeah, please. Yeah.
Yes.
Yeah. Yeah. And so, and I did post about that one just a couple weeks within the last week or so. I got and it really aggravated me. It's a template that my client uses. So it's, most of it's pre-filled, and that you just have to plug in some information. And it literally in 2 paragraphs. And I went back, I'm like, oh, look, here's 9. He had 9. I shouldn't say the attorney had 9 glaring typos. And it wasn't 2 TO versus TOO. It wasn't those type of typos or grammatical. These were just, to borrow from my defense attorneys, these were egregious typos. And I sat there and looked at it, and the managing attorney at that firm is a dear friend of mine. And so I shot him a quick email and attached it. And I said, hey, I do not want you to reach out to your attorney and tell him that I have reached out to you, because I don't want it to impact my relationship with him. Oh, and it's an attorney I haven't worked with before. And I said, if it continues to be a problem, I'll deal with it. But I'm letting you know, because as managing partner, I assume you want to know, because I would want to know. And
Sure.
In case from my standpoint, what this tells me is either A, you had somebody type this for you, you dictated it, somebody transcribed it, typed it, and you didn't bother to look at what went out under your name, or you did it yourself and you just don't give a rip. And you're careless. And either one of those things, that's a big problem. I'm not saying you can't have a typo or 2 typos or miss a period or whatever. Where else are you being messy, careless, and missing things? And that's a problem.
Yeah. Well, and what you brought up, though, a very good point, though. I like that you went to the managing partner and discussed it, because I think any, that's your relationship, right? Is with that partner.
Absolutely.
And I think
Yes.
they, in that position, they want to know if they're not seeing the work product getting produced to you, they're going to want to know if there's issues with it so they can address it on their end. So I would think that attorney probably really appreciate the phone call.
He did. Yeah, absolutely. And I think, I'm sure Porter would agree. As much as I gripe sometimes, and again, my LinkedIn thing is just my little vent outlet. I'm not cranky 100% of the time, I promise. But I reached out to the managing partner because A, he should know that, and B, over the last year, I've really kind of had a change in mindset and reminding myself what I used to gripe about, excuse me, to other folks, which was, I can't read your mind, right? I mean, Porter and I didn't get our jobs and get to where we are because we're mind readers, because nobody is. But we should extend that same courtesy to defense counsel. So I've kind of gotten along this vein of, if I don't tell defense counsel, and it's defense counsel that I don't have a long-standing relationship with, if I'm not very explicit and here are my wants and needs, and here are the things that aggravate me to no end, well, then I have to own part of that when they don't meet those expectations, right? Because they're not mind readers. I haven't retained them for their expertise in mind reading. And if I haven't told them, here's what I need from you and here's what I don't, and maybe go the step beyond of, here's why I'm asking for these things or why I need these things, here's how they impact my desk, then again, I have to own half of that when I don't get what it is that I think I need or want.
Yeah.
I replied to your comment and I got some feedback about it. My twist on that is especially in your example of a 2-paragraph correspondence, it's a lack of respect. If you can't take a 2-paragraph reply and fix the pronouns to be applicable and correct some of that, I realize that there's a unique relationship between an adjuster and his or her defense attorney, but it just doesn't take too much to sort of complete the circle and do it correctly. And I agree 100%. They're not mind readers. So yes, they have to know exactly what we're thinking in order for them to effectively do their jobs. And I think that spans across the entire claims process. They need to know
Absolutely.
My definition of a good settlement and an attorney's may not be the same. Your definition of a good settlement or a reasonable request by the other side is going to be different. So I think communication is key. I just think it needs to be well done communication, properly done communication.
Yeah, I would agree. And I think I don't care so much that my attorneys respect me personally. I mean, I hope they do, but I need them to, maybe it's not a respect thing. I want people to take pride in their work. Mm-hmm. And because I do. I don't meet that bar that I set for myself all the time. I mean, I got an email from my supervisor the other day. Clearly, I'm not meeting a bar somewhere. But I take pride and self-respect in my work product. That's important to me. And when I have an attorney who I don't feel like does, you don't get as good of results from those people. The best results, I think, come from people who take pride in what they do and they take ownership in what they do. For example, I had an expert one time, I kid you not, and he was constantly, his reports were spelling errors, grammar errors, spelling errors, grammar errors. And I kept overlooking it, grumbling until the day his report came and he had signed in his signature, he misspelled his own name. I'm not kidding. His name, I think his name was Greg. It was either Greg or Brian. And he misspelled his own name. And I canned him. I said, I can't do this anymore. I mean, if I don't know what else telegraphs more clearly that you just don't give a rip about your work. Yeah. And, let's face it, your work is my work because that goes into my file. It goes into Porter's file. That's our work.
Right. And then you might have someone above you looking through the file and
exactly.
Like, what's this bozo telling you that brain? Who's brain?
Yeah, exactly. And then, the next part of that is, well, Morgan, Porter, you clearly don't know how, you clearly can't manage retaining good vendors. Because your vendor can't even spell his name right. So it reflects, not only does it reflect badly on you, it reflects badly on us. And I don't know about Porter. I don't like that. I do enough damage on my own I don't need my partners out in the industry helping me with that.
Yeah.
Right. When you have the ready, fire, aim mentality that I sometimes employ, I don't need to pile on with like you say, with a bad file. I don't need
Right.
any reviewing anything that's going to be questionable or just again, make them wonder. If you use the word pride, that's a great word. Wondering if I have, a little bit of pride in how the file looks. I mean, you almost get it to that personal of a level because it is yours. It is mine. It is something that has our name attached to it. And it's something that we get credit for one way or the other.
Absolutely. And we get the dinks for it, as we should. I'm a big believer in it's my claim. So at the end of the day, I'm responsible for every screw up on that claim. Doesn't matter who did it. It's my name on it. I have to own that.
Well, and I think from like an attorney perspective though, too, and it veers a little off course, but like as like partners, if you have an associate working for them, like their mistakes are my mistakes.
Absolutely.
Like, because my
Yes.
name is on that filing. So, and I think I'm doing myself and them a disservice if I were to blame them. Like I am the final check. And it same goes for a paralegal or an assistant, anybody. Like it's not their fault. I'm the final check.
Right. Well, it is their fault. But it's partly their fault. But yeah, the fact that it made its way out into the world, that rests on you or
Yes.
me or Porter or Nate, as the case may be. But yeah, that ultimately, whoever is the top person on that file, you own it all.
Yeah.
One question I had, Morgan, that we didn't really cover last time was when you've brought up these kinds of issues to counsel, whether it's right to the person reporting to you or whether it's to a managing partner or that person's supervisor, what is the response? Do you ever get pushback beyond just a unequivocal apology? Do you ever get excuses or anything like that?
No, I don't. And I think part of that's probably my personality. So, I've been told I can be a little intimidating. I certainly am. What word do I want to use? I'm not abrupt, but I'm very, it is what it is. And here's what it is. I have had a couple of times, I've had attorneys, actually, yeah, a few times when I've had to chase an attorney for reports or questions or something, and I'm chasing and I'm chasing and I'm chasing, and I finally get to the point where, and I've just flat out asked, I said, if you do not want to handle this file, please let me know and I will reassign it to another firm. And I had an attorney finally at that point come back with a lot. Oh, well, so-and-so got sick and this and this and this. And I didn't say anything, but I've never used that attorney again because I had been chasing him for pretty hard for probably 30 days.
Yeah.
And
You spoke to him, you just didn't tell him anything. That not
yeah,
you
exactly.
speaks to them. Yes.
Yeah, but my thing is, look, I'm not heartless. I have stuff that blows up in my life. The last 3 weeks of my life have been a nightmare. There's a lot going on. But if you don't tell somebody that, if you just ignore them, well, it goes back to, of course, these are our files and we have people above us looking at them. So somebody's going to come into my supervisor is going to come into my file and see that I've been chasing defense attorney for 30 days and I'm getting no response. A, Morgan, why'd you hire a crappy attorney? And B, Morgan, why don't we have this information developed? So, but if the attorney had simply emailed me back and said, I apologize, I will get to this as quickly as I can. Currently, my wife is in the hospital. Currently, my wife just had a baby. My mother has COVID. My uncle died. The dog ate my shoes. Give me something, right? Give me something that I can put in the file that not only is going to cover my behind, it's going to cover yours. Because 95% of the attorneys I work with, I want to continue to work with. So I want I want my client to have faith and confidence in you as well, so I can continue to use you. Because if you look bad, I look bad. And if you look bad enough, my client may not want to let me use you anymore.
Yeah.
So if you're not giving me cover, I can't cover both of us with the client.
And again, it goes back.
Sense?
Help me help you.
Yeah.
Exactly.
Well, it goes back to communication, the mind reading. Like, again,
Yes.
like you can't read the mind. You don't know what's going on in anyone's individual life.
No.
And you're not asking for details or
No.
specifics, but, if it's been, a number of days, just or weeks, a note just to say, hey, I see your message. There's a reason for my delay. I'm not just ignoring you.
Exactly.
Because I don't care.
Right. Again, over the last, since my son is deployed, I've been practicing and preaching, but nobody knows what's going on. I don't know what's going on in any of your lives, other than I know Nate's having a baby. But I don't know.
My wife is, but I'm involved in small.
Yeah, you're involved. Okay, you're involved.
Yeah.
But I have no idea what's going on in your life, and so I'm trying to remember to not only give myself a little bit of grace, but more importantly, to extend that grace to other folks. But if you just ignore me, then I don't know that I need to be extending you any grace, right? So it's just, and I've always said, an email takes 30 seconds, maybe a minute to do what you said, Megan. Just, hey, I see this. I've got some stuff going on. Give me 2 weeks. Now I can cover not only myself, I can cover you too. And I'm not sitting here getting aggravated because I'm getting ignored. I don't know about Porter, but one of my pet peeves, don't ignore me.
Mm-hmm.
Well, communication is the big thing, but it goes back to what we've all talked about, the relationships. You mentioned your relationship with the managing partner. None of us on the adjuster side, and I would suggest that Megan and Nate don't like this either. When we get out to a conference or go out to a happy hour or something, every once in a while you'll see an attorney you've used in the past, and invariably you have that awkwardness of, hey, I haven't seen anything of yours come through our office recently, or even sometimes it's, why did you stop using it? And I think that's part and parcel of what you're saying a little bit, is that I don't want to take the time to rat anybody out necessarily, or I don't want to, mess up somebody else that may be going through something that I didn't know about. But those awkward conversations from the adjuster side can be tough. I can't imagine from the law firm side, if it's someone I've got a relationship with, but another lawyer in the firm kind of blew it like you're describing.
Yeah.
It just adds to the awkwardness, and you've spent so much time building the relationship that now it's more, I hope I run into you at this conference or whatever, but it's not going to be in the business setting anymore.
Yeah.
Right.
So I lost my train of thought, but one thing I wanted to pivot a little bit out of, this issue to talk about, because one thing we didn't talk about during Morgan's podcast, and I want to make sure we don't lose sight of it today, is expert retention, because, and your thoughts on recommendations from counsel, because I think sometimes some attorneys have the tendency to recommend, we need all of the experts, every single one. And I'm curious from your point of view how that is received. Like, do you need, in my view, I don't think every case needs every single expert under the sun. You need to pick your experts wisely. But I think in some respects, some people are like, oh, well, but what if we need to get this person, we need to get this person. So I'm curious from your point of view, how you look at that.
Porter, you go first.
Okay, mine will be easy. I only do work comp claims. That's all I do. So in my world, when we use experts, they're going to be expert doctors, or they're going to be expert may be too strong a word, but something like surveillance, something that's going to be usable and valuable down the road. Yes, sometimes I do have to rely on my defense attorneys for that, because I want somebody, number one, that they know, have a relationship with, but someone that I trust their judgment enough on so many things. It seems like I've got to trust their judgment with, hey, this doctor's a good one for us, or I've used this surveillance group does A, B, and C that makes, they know exactly what we're looking for. Yes, I think relying on, in my world, the defense attorneys are pretty vital in that. I'd have to say, yes, I rely heavily on, because again, I do it in multiple states, so I'm not as familiar in some areas as I am others. So yeah, the defense attorneys they play a vital role in that. And, I've got to rely on them.
What about you, Morgan? Do you find that sometimes you get like too many recommendations to retain too many experts?
Fairly frequently. And you guys have probably seen it before I even go too far into experts. My big pet peeve was on LinkedIn, where my defense counsel told me I needed to retain an attorney, or not retain an expert. Yeah, my defense counsel said we need an attorney. That would
new attorney.
Yeah. That would not be a resounding vote of confidence. But anyways, so
honesty at a new level.
Yeah. We needed an expert. And I said, okay, great. Get me their CV, their rate fees, and a budget. So they did that, and I went through, okay, great, whatever. And then I said, fine, we can retain them. Their budget was, I forget how many hours it was, but I think it was 4 to 6 hours. And based on their fees, it was going to be between $42,000 and $6,000. So great, retain them. They send me, hey, the expert needs a retainer fee, which is very common. I get it. The retainer fee was non-refundable and $6,500.
Ooh.
And this was, and this was actually the same attorney who she was a mess. The same attorney who told me in a report on page 3 that my plaintiff had died. And the same attorney who told me on page 11 of that report that settlement value was now $7.5 million. All the same attorney. And she didn't understand. And I got a fair amount of pushback when I said, I'm not retaining an expert who wants a non-refundable deposit that is greater than the top level of their budget. That's ridiculous. It was ridiculous for the expert, and it was ridiculous that my defense counsel either A, didn't catch that, or B, just assumed I wouldn't have a problem with paying out an extra $500 to some I'm not going to give you guys an extra $500, and we're friends. But I get it because I do GL. I have a lot of experts all the time. And I push back on my defense attorneys because sometimes they want to retain 6 different experts right at the get-go. And I feel like sometimes they don't match the experts to what the likely outcome is of the case. Is there are some where we all know it's never going to go to trial. We all know we're going to go to a mediation and we're going to settle this. And we all know it's probably going to happen at the close of discovery or sooner. And do we really need to retain all of these experts if we know we're not going to trial? And I feel like it's almost like some of the attorneys, I feel like I've just turned them loose in a candy store and they're 6 years old. Yeah. I want this one, I want that, and I want this, and I want that. You can't have it all. So yeah, it's that part is frustrating to me. And I think one of the other things that's frustrating to me, and maybe it's just because I'm not as smart as the attorneys and the experts, but when they send me a CV that's 8 pages long and I don't understand any of it.
Like those 30-page reports, right?
Yeah, exactly. I mean, I don't understand that this isn't telling me anything useful. When maybe send me the CV, but also tell me I've used this expert on these 5 other matters that were similar to yours, and here's how they were able to impact and add value to this matter. That would mean something to me. But their CVs don't mean anything to me. And then honestly, Porter, I don't know what kind of reports you get with work comp, but a lot of when they do, the experts, when they send the reports, I don't know what they're saying. Send me a report. Great. If you have to use all the big words and if you have to pontificate away, go for it. But please give me a 3-paragraph summary for the layperson. The same thing that, because I read that report and all I'm hearing in my brain when I'm reading that is, if this is what you're going to tell a jury, if we do go to trial, if this is how you speak to the jury and how you explain it to the jury, their eyes are going to be glassed over. Just like
it's Charlie Brown's teacher sound.
Yes. Womp, womp, womp.
Exactly.
Yeah.
Exactly. Yes.
Well,
So
Morgan, let me ask you, do you see your experts, do you see them on both sides of the aisle sometimes? It's almost or do you pretty much, I run into it where it's almost a race to the expert. They're an expert for hire.
Oh, absolutely.
And,
Yes.
and in some cases, I have agreed with defense attorneys, we might need to pay a small retainer somewhere, if no other reason, to keep the other side from hiring.
Yes. And that I would agree with. Yeah.
That's
to where
that makes it more of a ploy in the chess game than it does a vital part. But I think some people are just better at the writing. Some people are better at testifying in front of in the courtroom, where you don't want them there on the other side.
Right. Yeah, I've got a carbon monoxide poisoning case right now that's got a pretty hefty exposure. And we've retained one expert, I can't remember which one it was, but we retained one that I don't think we're going to need. I hope we're not going to need, but it really was more a defensive maneuver in that we wanted to pull him out of the available pool because he was the best expert to be had. So I don't want plaintiff attorney having it.
So it's like coaches say, defense creates offense. So
yes,
sometimes you've got to be proactive that way.
And there's certain
Absolutely.
cases that you do need to forecast an outlook. Be like, okay, we have a very distinct cause of action here. We know, like in this particular case, there's probably only X amount of experts available. So we might need to jump on that soon. But if you have your run of the mill, slip and fall, maybe the orthopedic issue, but there's a liability issue, maybe you don't need to retain an expert on day one. Maybe you're going to fight your liability issues and see if it's a summary judgment case, if it's a real good summary judgment case, maybe you hold off on the expert and see how the summary judgment plays out if it's not going to be a race for that specific expert. I think it's a matter of just evaluating the case in front of you and not just checking the boxes and being like, okay, well, there's, a lost wages. Okay, we need, an economist. We need this, we need that. You might not need all that. And I think it's a thoughtful consideration to, the case in front of you.
Exactly. I mean,
it's almost a don't panic yet.
Yeah, maybe we need a panic button. Yeah, we haven't hit the panic button yet. Let's not do this. And, and I think it's a mindset too of, are we litigating to litigate? Or, I've taken recently to asking my defense counsel fairly often, what's the exit strategy here? Because I feel like on some of them, and I think adjusters are just as guilty of it. I know I have been occasionally. I think we get we get down to the trenches and we're down there and we lose sight of we're just reacting to litigation. What's our exit plan? What's our exit strategy? I mean, it may not work, but we better have an exit strategy. And we should be looking at that right when we get a new claim. We should be looking at that 3 months in. We should be looking at it when we're getting near to discovery being over. I mean, we should be looking at that and reevaluating that fairly regularly, because it's obviously going to change. But we need to know, because that should dictate everything just about, including, okay, do we need these experts now? Do we not need, can we wait? Do we need to lock them in now? Can we wait 6 months? Are we never going to need them? We need to be having that discussion fairly often.
Well, I think it comes to, sorry.
I think that's something that's so you could learn so early in the case. I think a lot of times attorneys will put their head down and they'll almost say, we're just preparing for trial and we have not looked at anything else besides we have our blinders on. It's either going to settle at mediation or a trial, but it's going to be after discovery. We're going to take the depths. We're going to do the written discovery. We're going to get the experts. It's almost like a checkbox. And then at the end, attorneys will sometimes say, well, now what? Now what do we do? I guess we should settle. But what we try to value in our cases, and Megan, we've done this for years and years and years, is try to get within 45 days the valid exit strategies out to the adjusters. What can we pursue? How can we pursue it? And then if none of that works, we prepare for trial. But I think people oftentimes look past the fact that you can analyze that fully within 2 months at the very most. Even with a really obstinate obstructionary plaintiff's attorney, you can still get the meds, you can still research the claim, you still have a complaint, and you could really do a lot of research without a ton of time and before you get into the heart of discovery.
Yeah, I think a lot of this arises out of a check the boxes type approach that Nate was talking about. Like, okay, you don't really need to do everything. You need to do what is necessary for your exit strategy, and you need to identify that exit strategy. Be like, okay, maybe I don't need to serve 6 sets of written discovery. Maybe I don't need to retain 6 experts, off the bat. Maybe I can pick up the phone and have an honest conversation with plaintiff's counsel and figure out it. Maybe we can settle this early. Maybe there are other options. But I imagine from Morgan and Porter, your shoes, like the check the boxes approach must drive you Maddie, whatever, crazy. Because I think that also kind of speaks to like having a careless counsel that, was a big theme in the first, big discussion we had during this podcast. Is you get those reports with lots of typos and errors. I think you see the same kind of results if you have a check the boxes approach. It's just not thinking about the case, just kicking the can down the road.
Well, claims don't fall into a nice little flowchart checklist type scenario. So it kind of throws it out the window pretty early with, what's different about this one? And you kind of got to go from there. And you can tell some of these are, in my world at least, some of these are going to be problematic for a variety of reasons. Some of them are a little more boilerplate, and maybe, yes, there are different times once you gather the medical records and do some things, it's going to be right to settle. So yeah, it's hard to fit a thorough enough checklist for each claim. So why bother?
Right. I think the checklist comes, I think sometimes maybe out of inexperience and then comfort. Maybe it's just like, oh, I've always followed this checklist, so I'm going to keep following the checklist. But checklists are great. If you're a new attorney, it'd be good to have a checklist. Be like, if you don't know what you're doing, be good. But it's not the end all be all. Like, you shouldn't always be following that, but it's a great start, I guess.
Yeah. Well,
let's not get ourselves. Sorry, Morgan, go ahead.
Yeah.
I think a checklist is, because there's always going to be certain, the adjusters, we have checklists, right? I need to contact the insured. I need to retain defense counsel if I have defense counsel. I need to review coverage. There's just absolutely some things that we need to do on everything. But the problem is when you become so rigid with that checklist that you have, that you can no longer look past it, beyond it, beneath it, above it. You're just stuck in the box and you can't think outside of that box. Yep. And everybody on this conference call knows claims, you better be able to think outside of the box, and you better be able to do it quick to get good results continuously.
Yeah.
And if you can't do that, you are not going to get the consistent good results that you want.
Yeah. So one thing I wanted to bring up, because Morgan, you brought up budgets, and the issue with the attorney you had with the over budget or under budgeting the expert. How, when you get budgets from attorneys, what is the bothersome level when you get budgets that like clearly there's no thought put into them? Because I think budgets are very important and you need to put a lot of thought in them, but I think that's not always the case. I think a lot of times it's like, well, this is a slip and fall case, so the budget's going to be X. And I think sometimes there's a tendency to simplify them and not think about the actual costs of defending a claim.
Ooh, yeah. Excuse me. First, I have to admit, I don't typically look really hard at every single budget that crosses my desk. And I can't explain the thought process there other than, if a budget comes across my desk and it's $25,000 up to point of trial prep, I don't really go through that budget and pick it apart. And very rarely do I pick apart the budgets that my defense attorneys send me. If I get a budget that's $180,000, $200,000, $250,000, $300,000, that I'm going to stop and look, and kind of think, well, why is this big? But I think what I can say is when your budget continually changes over the course of the claim, and if there isn't something crazy that has come up that none of us were expecting out of left field, if there's former plaintiffs have joined, or if we discover there's 3 other parties that we need to cross in, if there isn't something crazy that's happened or really unexpected and your budget increases by 50% and 60%, I'm going to call you up and we're going to have a talk, because that should not happen. I just have, there's an attorney who's going to get a unpleasant email from me probably next week. Ooh. Because they sent me a hey, we need this expert. And okay, so tell me why, because I don't ever let my get just randomly retain experts. You better have a good reason why. We talked about that. Here's how they're going to impact my claim.
Yeah.
So I said, okay, get me their fee schedule, get me a budget. And the budget came back, I think, at $30,000, because I'm sorry, experts, but you're all grossly overpaid. And I asked them, because I can't remember what right now, but I knew, because their budget was probably, I want to say it was maybe 45, something like that. So I knew right away that expert wasn't in their budget. And this is a very new claim. It's not a claim we've had for a year. I think it's less than 6 weeks old, maybe 8. So I emailed and said, hey, does your budget include this expert? No, it does not. We'll get you a new updated budget. Well, when I get the new updated budget, I'm going to be annoyed, because we're so brand. You clearly knew you were going to recommend this expert. Why isn't this in your budget?
Yeah.
Or if you didn't know what it was going to be, why didn't you send your budget with an email that said, hey, Morgan, the budget is X amount. Here's, it's attached, but we're going to recommend we retain an expert. So it's going to increase. We just don't know how much yet. We think it's maybe going to be this amount. And here's why that's going to annoy me, and that's going to be a problem for my file. And here's me saying, you guys aren't mind readers. That's going to impact my file, because I have put up that budget already. And Porter, I'm sure you same thing at yours. Clients don't like us to stair step reserves. And with that new budget, it is going to be over my authority. and I'm going to have to go to the client, which means I'm going to have to go to my supervisor, which means I'm going to have to do a TPA summary. And they're going to, I mean, it's a whole bunch of work. And I don't mind necessarily doing the work if we need that reserve. But the client and my supervisor are going to look at me and be like, well, you just put up this amount 2 weeks ago. Why are we now increasing this?
There are times I can use a defense budget as a means to settle a claim.
Mm-hmm.
And I don't want to say convince the employer, that's not fair to the employer, but it goes to show them if we fight on, and I'm happy as I can be to fight for you, fight on your behalf. But if we fight on, here's what we know we're going to spend. And then, of course, there's no guarantee of winning. So we still may lose on top of paying, I think the budgets are a good idea. I think they do require the right amount of time and the right amount of inclusion. Yeah, don't leave in my world, a medical depositions out of it. Don't leave the fees for some of these things out of it. So yeah, I think they're great.
Yeah, I mean, I use budgets a lot, like in cases that even we have lower liability exposure. Look, we can fight this till X, but it's going to cost us Y, but it's worth Z. So maybe we try to settle it now for Z, because I don't want to spend you up to Y when it's greater than Z. So, maybe we can try to resolve it. So I think a lot of times budgets are really important outside of just, knowing your costs and setting your reserves, to be like, hey, like, I'd love to, sure, I'll spend your money, but we don't need to.
We can make a business decision about settling a claim, like you say, so that Y doesn't become greater than Z. It's a business decision. Hey, we can get out now and kind of move on and fight again another day.
Yes.
Absolutely.
Correct me if I'm wrong, Porter and Morgan, but I think a lot of what you guys want to see is on the front end that we've considered everything, that we're not kind of shocking you later on down the road. In some of my budgets, and in all of, I think, Megan and I don't want to speak for Megan, but our jury verdict research, our pure exposure research that we do, I have made it a point in the last couple of years, because I think adjusters like this, to give caveats for two different ranges. I will say, here's a range that I think we can settle in. And here's what would get us to that range. If plaintiff is not credible, if we have a really strong damages expert, if we have, if we can find another party that we can maybe bring in and offset some costs. And by the way, if that stuff doesn't happen, if plaintiff is super likable, his or her injuries are really serious, our expert says there's no way he or she's coming back from this. We can't distribute out liability in any way. We're looking at a higher verdict, but I give kind of two ranges in the first 45 days to know 6 months or a year and a half from now, you can kind of track which of those things has happened and then see where we end up. And I think that's, Porter, maybe you could correct me if I'm wrong, but I think that's what you guys want to at least have in all of our heads at the beginning, that we've considered everything and that we're on
Absolutely.
Top of it.
I think it's important to be that thorough on the front end, because that sort of leaves things open, because no one knows as you get into a claim which direction it's going. Are people's medical is going to get worse? Are medical opinions going to become adversarial or become detrimental? Are we going to have witnesses that come up out of the blue that help you? Are you going to have witnesses that hurt you? I mean, yeah. So having the thoroughness in the first parts of a claim are going to be big. I think that's, and I think you touched on something else without really saying it that's important too, is you sort of do your jurisdictional research. You kind of know a budget based on what's the venue.
Oh, for sure.
What county am I in? What state am I in? That's going to change some of the, it's going to change some of the answers.
Oh yeah.
And I will add who the opposing counsel is, who your
Absolutely.
co-defense
I was going to
counsel
say
is.
the same thing.
Yeah, I've done a bunch of budgets where I say our discovery motion budget is much higher than it normally would be, because this plaintiff's firm, for lack of a better term, stinks. They don't respond to you. They're obstructionary. They're known to be that way. So we're going to have to file a motion to compel for everything we want, whether it's a DEP, a subpoena, a discovery response, et cetera. And then there's others that respond quickly, and
Yes.
we leave that low. We won't have a lot of issues with that. We may need to fight for more specific answers, but we'll get answers timely and completely. And so I think that matters in budgeting too.
That's obviously a very vital part of this whole scouting report type sports analogy I'm making, but not only the jurisdiction and the judges and how they do, but certainly the opposition, how thorough they, do they own a bunch of neckties? Are they want to go to the mat with something, or are they going to settle at some point because that's how they deal with volume? So yes, knowing all those things and make the budgets very vital on the front end.
And to, ducktail off of that with motions, because I love that Nate brought up motions, because it was on my list of things to discuss today, is motion practice. And twofold, like one, identifying the counsel that there's going to be motion practice. And sometimes you're going to know that, sometimes you're not. Maybe you haven't dealt with that counsel before, but if it's one that you've dealt with, or you've dealt with that firm, you can give, the carrier a heads up, look, they file a lot of motions. We might have to file motions. But what are your thoughts on just motion practice in general? Like, I personally, discovery motions, I don't like to file discovery motions unless I really need to file a discovery motion. Like, if they're late on, giving me discovery responses, I don't immediately want to jump to filing a motion unless I know it's, again, one of those firms that it's like, look, we can try to wait this out 3 months. We're still not going to get anything from them. But I'm curious to see your perspective on motion practice, even, whether it be discovery motions or even dispositive motions.
Well, my part of that's easy. This problem we have is when one motion deadline encroaches on another deadline.
Yes.
And you have to go through the hassle of getting discovery responses in order to know your next step. I don't want to then go into the time and expense of trying to dig up medical records if in your discovery responses you've provided me with names and addresses. It's some of the piggybacking of one problem and one deadline on top of another that create the problems in my world. I'm sure Morgan can dive a lot deeper into that.
Oh, sure. Pawn it off on me.
Well, I think what Porter's saying, I'm sure Morgan has some opinions about motions.
Yeah.
Well said. Well said.
Yeah, Morgan has opinions about everything. So my opinion on motions is I think a lot of times it just depends on plaintiff counsel, right? Do we have a good working relationship or a non-adversarial relationship with plaintiff counsel? Because at the end of the day, we get more with honey versus vinegar, right? So, and extending grace. Okay, hey, maybe we get something by not pursuing motions that we don't need to when plaintiff counsel is not being responsive and not doing what they're supposed to be doing on whatever timeline they're supposed to be doing it on. And then there are other times where it may just be some stupid little claim that has no value, and plaintiff attorney is convinced it's 100,000 or 600,000 or whatever amount they think it is. But we know liability, we've got it. This is nuisance value at best, but it's going to be expensive to take it to trial. Sometimes I think you can use motions as a weapon, right? I mean, motions get weaponized all the time. And sometimes the message I want to send via defense counsel is, look, Mrs. Plaintiff Attorney, I have a bigger wallet than you do. At the end of the day, this is actually only a nuisance value claim, and I'm going to bury you in cost, in legal costs, because I am going to have my defense attorney file every possible motion that we think we can do and not get sanctioned by the courts. And so it really just depends, like so much of what we do, it depends on the claim. What I don't like is when defense counsel just tells me, hey, Dave, we're just going to go ahead and file this motion and this is what we need to do. I prefer that defense counsel, that we have a discussion where it's plaintiff attorney hasn't done this or did do this. We can file this motion. Here's what we think the outcome will probably be. Here's how long that it's going to take to get to that outcome. And here are the pros and cons for doing that. And maybe here's what the additional increased expense may be. But let's have a discussion before you go willy-nilly just filing motions, because we're back to the checklist, right?
Yes.
Well, and I think there's a great example there of we're a we, so we need to talk about it.
Yeah.
More it being one-sided, but more importantly, every once in a while, if you get a plaintiff firm that seems to have an in and have 2 or 3 of your claims all of a sudden, sometimes you got to send a message.
Mm-hmm.
You want them to think twice before they take the next file against this particular employer, because they get me in the bargain.
Absolutely.
And I want to create such a
reputation.
Yes, I want to make an impact so that they go, oh God, not again. Not so much with motions, although they can be effective, but I think it's also just, this is not your free ticket this is not your pull on the slot machine. You're gonna punch the time clock. And I'm gonna
I've got a great example for that. 20 years ago, and I was working at a carrier, and I was relatively new, and we had a school account in around Pine Bluff, Arkansas. And we had this one claimant attorney that, the buses they'd roll into a car in front of them where they'd get in an accident and it would be the bus driver's fault. And inevitably this one claimant attorney would show up and he would have 18 kids on the bus. The same demand packages would come through for every single one of them. They all had the exact same treatment. And this employer of mine was routinely settling these for $5,000, $6,000, $7,500. And I was like, what are you doing? This is the perfect example of Pavlov's dogs, because he doesn't have to do anything. He sets up shop, and now all the parents, everybody knows there's a bus accident. We all just go to, claimant attorney John Blow, and claimant attorney John Blow sends them to, Mary Jane chiropractor, and they get X amount of treatment. And then attorney John Blow writes up these demand packages, and he just puts in the different names and the date of loss, because they're all the same. Yeah. I was like, what have you done? So I said, we're going to stop this. I'm going to get an attorney on every single one of these, because these are all minors. And technically, legally, this needs to go through the courts, and they need a guardian ad litem. And the parents are going to have to go, the parents are not going to just get a check to go do whatever they want to do with. Everybody's going to have some hassle. And the biggest thing was, because I'm tying up their settlement money, all of these parents are going to be calling claimant attorney Joe Blow constantly. And they did. And, yes. I told my employer, I said, look, it's going to cost us a little more on the front end, because we're retaining an attorney. They have to, we have to go through the courts. But I promise you, in 6 months, this landscape is going to look vastly different. And in 4 months, we never got another claim from him. Not a one.
Send a message. Got to send a message sometimes.
Yeah, exactly. Sometimes you just, because if what I think Porter said, your free ticket, I refer to it as the ATM. And if they just look at Porter or I and they see, oh, look, I punched my ticket, or, oh, look, there's Morgan, the ATM. Why would they stop? they're going to continue to come get the ticket from Porter and make the withdrawal from my ATM.
And by the way,
So-
it's not just plaintiff's attorneys themselves or within the same firm. It's all plaintiff's attorneys in a given city or region.
Yeah.
Because
Absolutely.
they're all on a listserv. So if someone gets a good result, they put it on the listserv, and it's Morgan Dooley, and here's the insurance carrier, and here's the client, and there's a blueprint there. You issue this discovery, do this, include this in your complaint, and you get a check. And I think it's not just with a firm, it's so pervasive amongst all plaintiffs firms because they're all on these listservs and share their information.
Yeah. And
So
that's a
their
whole
scouting
other,
report.
That's right. Yeah.
yeah. And that's a whole other like bag of worms too.
Yeah.
So we're almost out of time, but one thing I wanted to touch on before we wrap up is, because I'm curious, if you have counsel and you see some of these issues that we've discussed today, these mistakes or errors or lack of judgment or communication, is there a way for that counsel to redeem themselves in your eyes? Are they dead to you forever, or yeah?
Well, absolutely, but no. Absolutely, but no.
I'm glad you took that one.
Yeah. The attorney who told me on page 3 that the plaintiff was dead when in fact the plaintiff wasn't dead, and I discovered that by calling plaintiff attorney, who said, no, I just talked to my client an hour ago. And then when I pointed that out to my defense attorney, then she argued about it. No, there's no coming back from that.
What did she say? Did she come back from the dead? Like, what was her?
Oh, no, she's replying, and she kept doing
You
it.
sent flowers to the wrong place.
Yeah, I canned them, and she's still emailing back to me and new defense counsel. I can't make this up. All in bold and caps. The plaintiff is dead. I was like, no, he's not. I talked to plaintiff counsel. I did what you should have done, which was call plaintiff counsel and say, hey, my insured is saying that your client is dead. And then plaintiff counsel would have told you what he told me. But anyways, no, you can't come back from that. But if you screw something up, again, and I'm sure Porter's going to say the same, we're not infallible. We make mistakes. So if again, it's another thing I'm working on, self-improvement. I am trying to find the ways to come to my defense counsel when they are doing things that are problematic. I'm trying to ask myself, am I asking my defense counsel to be a mind reader? Because if I'm asking my defense counsel to be a mind reader, again, I have to own that. That's my problem. And I need to teach my defense counsel, look, here is why it's a problem when you send me a 53-page report. Don't do that. I don't want a 53-page report. And here's what I need instead. And so that you can come back from that, right? Sure. You can say, okay, I wasn't aware. Thank you for letting me know. And I will make sure that we don't send reports of that length to you in the future. And if you have a good attitude about it, and we both approach that as grown-ups and nobody gets their feelings twisted up in a knot, then we're okay. But if you get snarky about it, or if you argue with me and tell me why I am wrong about what I want, or if you continue to ignore, if you send me a 52-page report the next time or a 49-page report, then you can't come back from it, right?
That's right.
So,
there are some things that are certainly recoverable from. We all make mistakes. We all value things incorrectly. We all guess incorrectly. We do all those things, and we're all culpable for that. Yes, if something's pointed out, Morgan and I don't get to recover from making the same mistake multiple times generally. Neither would a defense counsel. Anything it is. Don't make assumptions. Don't do things without talking to me. There are some things that pretty much can be one and done. And then there are quite a few more things that would be, you can talk it through, explain why. Maybe I'm a little different. I admit that. on the front end. I'm going to be a different type person for you to represent. Here's why. But let's talk about it. And some of your things, you know, I'm going to try to live outside that box a little bit that you described earlier. And you know, I may want to, there's a reason I might want to fight a particular issue, or I may want to fight a particular thing. And I just need you to kind of go along. Don't make decisions on my behalf, and don't, you know, don't mess up a good thing.
Yeah.
I mean,
I will say though, because this was just on my LinkedIn too, the attorney who had his secretary call me to set up a conference call to discuss settlement recommendations is probably not going to be able to recover from that, because that to me is just an overarching lack of respect.
yes, that's
that I'm just, no, we're probably not going to work together again.
Like I said, there are some one and done things. There are some things you can recover from. It's a matter of timing, and it's a matter of degree.
Mhm.
yeah.
Yeah, you know, we recently had a really large exposure claim out in New York, and defense counsel was giving me fits. I mean, just fits, and was giving my client the same fits. So we reached out to a managing partner that my client had a relationship with. I did not, and talked to her. And then she said, well, let me go back and talk to the attorney that we had handling it. And she did. And then she, you know, it's with some of our concerns. And then she came back to us and she said, because we really were ready to can him off the file, which would have been expensive, but that's how unhappy we
You gotta
were.
do it sometimes, yeah.
Yeah. And she came back and said, I think there's been some miscommunication. So if it's okay with you, I'd like to set up a conference call. So we got on a call with my client, me, the handling attorney, and his managing partner. And we were able to talk through, here's what we're needing. Here's what we think you're telling us and what we're getting from you. And we were able, it was a little awkward. I'm not going to lie. It was a little awkward. And I felt kind of like a snitch or a tattletale. But that we really needed to address this. So we got things ironed out. We came to a good understanding. It was a little awkward after for a little bit, but we ended up getting a great resolution, and I will use that attorney again. But that we were able to do that because it goes back to this overarching theme we've had on this call, which is communication. And nobody is a mind reader.
That, hey, I was going to do the sum up and you did it for me.
Yeah, there you go.
Well, you know, I appreciate both of you, and I'm so honored and glad that you came on today. If you know, I think we could probably talk about this forever. I would say, if you ever in the Philadelphia region, call up Nate and I. Let's go out to lunch or dinner. let's hash it out some more. But truly, you know, I really appreciate your insight on, you know, the do's and don'ts of counsel. And I think any attorneys out there listening appreciate it. And I think all the adjusters listening are like, yeah, me too. Like, they're going to send me an email like Porter did last time we had you on, Morgan. Well, you know, again, thank you so much for coming on. And then for all our listeners out there, as always, if you like what you hear, please subscribe to us, to the Defense Never Rests on Apple Podcasts. And now you can find the video portion of our podcast on our new YouTube channel, which is TDNR Podcast, which was just launched this week. We're filming this the first week of January. So thank you all.